This module concerns the choice of the applicable law in international arbitration. One of the reasons that commercial parties agree to international arbitration, to international commercial arbitration, is because of the certainty and predictability that the arbitral process provides to them. Commercial parties generally desire a predictable and certain framework within which to conduct their contractual relations. International arbitration seeks to provide that framework, both procedurally and substantively. It seeks to provide a neutral procedural framework within which the parties' disputes can be resolved, and it seeks to facilitate the selection of a predictable substantive framework, a substantive legal framework for resolution of the parties' underlying dispute. We can see an example of one court's recognition of this desire on the part of commercial parties, the Shirk versus Alberto Calvo case, which is excerpted on the current slide. The court underscored the importance of predictability and certainty in the resolution of international commercial disputes. In international arbitration, it's important to distinguish between several different potentially applicable laws. These potential choices are listed on the current slide. And we can see them. First, the substantive law applicable to the merits of the party's dispute, the party's underlying commercial contract, the party's non-contractual claims and disputes, such as breach of fiduciary duties or misappropriation of trade secrets. That's one of the potentially applicable laws in international commercial arbitration. In addition, there's separately the law applicable to the separable international arbitration agreement. And finally, there's the procedural law governing the arbitration. This decision by the House of Lords in the Channel Tunnel Group case, which you can see excerpted on the current slide, explains the differences between these three types of law. The substantive law applicable to the parties' underlying commercial relationship, typically their contract. Second, the law governing their separable international arbitration agreement. And finally, the procedural law of the arbitration. In this webinar, we're considering the substantive law applicable to the merits of the party's underlying dispute, the contract law, the tort law, the corporate, or other type of substantive law that governs the party's underlying commercial relationship. As we'll see, arbitral tribunals, international arbitral tribunals, have broad authority, broad discretion to select the applicable law. That authority is recognized both by national arbitration statutes and institutional arbitration rules. Pursuant to both those sources of authority, national arbitration law and institutional rules, arbitral tribunals' decisions on the applicable law, the applicable substantive law, are subject to only minimal, de minimis, judicial review. Let's look at two basic scenarios. These are the two scenarios that typically occur in practice. First, let's consider how arbitral tribunals both can and do select the applicable substantive law in the absence of any choice of law agreement, either express or implied, between the parties. And second, let's look at the choice of law agreements between parties, typically in their commercial contract, and how, in those circumstances, arbitral tribunals choose the applicable law. Let's begin with the choice of substantive law in the absence of agreement by the parties on that issue. When the parties have not agreed on the applicable substantive law, an arbitral tribunal may either apply some set of choice of law rules or alternatively directly choose the applicable substantive law without any choice of law analysis. The arbitral tribunal's freedom, its authority to choose the applicable law in these circumstances, is recognized both by national arbitration legislation and institutional arbitration rules. We can see with respect to national arbitration legislation the UNCITRAL model law on international commercial arbitration from 1985. It provides in Article 28.2 that failing any designation by the parties, The arbitral tribunal shall apply the law determined by the conflict of laws rules which it considers applicable. A broad grant of authority to arbitral tribunals in circumstances where the parties have not designated the applicable substantive law to choose that by applying conflict of laws rules. The Swiss law on private international law also recognizes the arbitral tribunal's authority to choose the applicable law in the absence of any choice by the parties, as does the French Code of Civil Procedure. Each does so in slightly different terms that we're going to look at in a little more detail. Institutional arbitration rules recognize the same authority on the part of arbitral tribunals. We can see in the original 1976 UNCITRAL Arbitration Rules, Article 33, subparagraph 1, recognizes the tribunal's authority to apply the law determined by the conflict of laws rules which it considers applicable, a broad grant of authority for the tribunal to pick those choice of law rules, those conflict of laws rules that it considers applicable. In the UNCITRAL rules from 2010, in Article 35.1, recognize an even broader grant of authority. The arbitral tribunal shall apply the law it determines to be appropriate, a broad grant of discretion to the arbitral tribunal to select an applicable law directly. There are basically 6 choice of law approaches today by arbitral tribunals when the parties have not included a choice of law clause in their commercial contract, when they've not selected the applicable law. You can see those 6 basic choices on the current slide. Some arbitral tribunals are required by the law of the arbitral seat mandatorily to apply the generally applicable conflict of laws rules of the arbitral seat. These arbitral tribunals, and this was the historic approach towards conflict of laws issues in international arbitration, these arbitral tribunals are required to act as if they were a local court, to apply whatever domestic choice of law rules a local court would apply. This approach, this historic approach, has largely been abandoned today, and arbitral tribunals, as well as courts reviewing their decisions, no longer require arbitral tribunals to automatically, mandatorily apply the choice of law rules of the arbitral seat in the same way that a national court would do in a local litigation. Second approach is applied choice of generally applicable conflict of law rules of the arbitral seat. This approach differs slightly from the previous one in that it looks to the parties' agreement on the arbitral seat and treats it as impliedly also selecting the choice of law rules of the arbitral seat. It's an implied choice which could be overridden by express provisions or by other indications of the party's intent, but it nonetheless produces the same result as the previous approach, namely requiring application of those choice of law rules which would be applied by a local court in domestic litigation. A third approach, the mandatory application of a specialized conflict of laws rule of the arbitral seat, is fairly common. We can see it, in fact, in the approach of the UNCITRAL model law in the Swiss law on private international law, Article 187, subparagraph 1 on the current slide. The arbitral tribunal under the Swiss law on private international law is required to apply the rules of law with which the case has the closest connection, a closest connection standard that is designed specifically, a specialized standard designed specifically for international arbitration seated in Switzerland. And a number of other national arbitration statutes have similar approaches, a specialized choice of law rule applicable only for international arbitrations. Some institutional rules and some national arbitration legislation, for example, the UNCITRAL model law, allow arbitral tribunals to directly choose the substantive law applicable in the absence of a choice by the parties. These rules do not require, these national arbitration statutes and institutional arbitration rules do not require the arbitral tribunal to apply a set of choice of law rules, but instead allow them to directly select the applicable law without any choice of law analysis. A final approach that is adopted by some arbitral tribunals, imposed by some national courts, is to apply certain mandatory law rules. For example, competition law rules or securities regulatory statutes to particular issues or types of dispute. This is relatively rare, an example of a public policy exception of sorts, but it is still seen in a few cases. The dominant approach among these 6 choices that we've considered briefly is the direct selection of an applicable law, or alternatively the approach whereby the arbitral tribunal has the discretion to choose that choice of law rule which it considers applicable or appropriate in a particular case. And arbitral tribunals' decisions on these issues are subject to only the most minimal judicial review. Like other aspects of their substantive decision, substantive resolution of the parties' dispute, arbitral tribunals' application of choice of law rules and their selection of which choice of law rule to apply is subject to only minimal judicial review in either subsequent annulment or recognition proceedings. Let's move on then to the second scenario that I outlined a few moments ago. This is a scenario where the parties in their commercial contract or otherwise have included a choice of law clause that selects the law applicable to their underlying dispute. The basic rule in this context we can see on the current slide. The basic rule is one of party autonomy. Parties are free to choose the substantive law applicable to the merits of their dispute. We can see that, for example, in Article 28.1 of the UNCITRAL Model Law. Its title says that it addresses the rules applicable to the substance of the dispute, the merits of the party's underlying commercial dispute. And that rule is that the arbitral tribunal shall decide the dispute in accordance with such rules of law as are chosen by the parties as applicable to the substance of the dispute. Institutional arbitration rules, the UNCITRAL arbitration rules, for example, prescribe the same rule. You can see that on the current slide, a basic rule of party autonomy. Note that this rule applies both to express and also to implied choices of law. The arbitral tribunal is required to apply the law chosen by the parties, if indeed they have included a choice of law clause in their underlying contract, or if they've made an implied choice of law. Note that in a number of jurisdictions, parties are free not just to choose a national law, but also to choose a non-national legal system. For example, the unidroit principles. Parties are not required to choose the law of a particular country, the law of New York or of Switzerland, but instead have the freedom to choose a non-national legal system. You can see that in Article 28.1, which allows parties to decide that the rules of law in a particular case governing their dispute will be a non-national legal system. In contrast, under Article 28.2 of the UNCITRAL Model Law, the arbitral tribunal is required to apply the law, not the rules of law, but the law chosen by the conflict of laws rules, which it considers appropriate. A few jurisdictions have limited the parties' autonomy to choose non-national legal systems. You can see examples: the Bulgarian commercial arbitration law and the Tunisian arbitration code on the current slide require parties like arbitral tribunals to choose a national legal system instead of a non-national legal system. What does a choice of law clause look like, a choice of law agreement, if parties choose to use their autonomy under Article 28.1? We can see several examples on the current slide. One common formulation is as follows: this agreement will be governed by, and all disputes relating to or arising in connection with this agreement shall be resolved in accordance with the laws of England. You can see other examples on the current slide. A somewhat narrower formulation: this contract shall be governed by the law of State X, interpreted and supplemented by the unidroit principles of international commercial contracts. Parties frequently don't include that latter part of the quotation that I've just read, the reference to the unidroit principles. They prefer simply to refer to a national legal system. Note that these different choice of law provisions have differing scopes. Some are broad and others are narrow. It's also important to compare the scope of your choice of law clause to the scope of your dispute resolution provision, your international arbitration clause. Most arbitration clauses are drafted very broadly. They apply to all claims or disputes relating to or arising out of or in connection with the party's underlying contract. If your choice of law clause is drafted more narrowly, if it provides only that the law applicable to this contract or disputes arising out of this contract, it will be regarded as having a narrower scope by some courts and tribunals than your underlying arbitration agreement. Some parties, therefore, prefer to draft their choice of law clauses expansively, using language that precisely mirrors that of their international arbitration clause or their forum selection provision. A final question is, how should parties in particular cases exercise their freedom, their autonomy to choose the law applicable to their underlying contract? There's no one-size-fits-all approach to this, and you can see in the current slide some of the considerations that go into selecting a law in a choice of law clause. As with other contractual provisions, it's a question of negotiation as well as of drafting. Both parties often will be suspicious about a selection of their counterparty's home jurisdiction's law. They'll prefer a neutral law or perhaps their own law. It's difficult to prescribe a single one-size-fits-all rule for all of these cases, but the better approach is to choose a neutral law of a developed commercial jurisdiction where the law applicable to the party's contract can be ascertained relatively easily from published decisions and statutes. There may be issues that are subject to mandatory local law, to public policy restrictions or public policy exceptions. These are typically very narrow and in general do not pose difficulties for international commercial transactions. Finally, let's take a step back and look at the choice of law rules in Article 28 of the UNCITRAL Model Law on International Commercial Arbitration. Again, this is a provision that's representative of, characteristic of the approach towards the choice of law in many developed jurisdictions. It provides, as we saw previously in Article 28.1, a basic rule of party autonomy. Parties are free to choose the law applicable to their underlying commercial contract, and once they've done that, the arbitral tribunal is required to apply that law. If parties don't make either an express or an implied choice of law, then Article 28.2 gives the arbitral tribunal broad discretion to apply those conflict of laws rules which it considers applicable. An arbitral tribunal may only act ex aequo et bono or amiable compositur in unusual cases where the parties have expressly authorized them to do so. These types of authority allow the arbitral tribunal to resolve the party's dispute without reference to rules of law, to simply decide what is fair, what's equitable, what is just. Only where parties have expressly authorized the arbitral tribunal to do so, however, does Article 28.3 and most other national arbitration laws allow them to do so. And finally, in all cases, arbitral tribunals shall take into account so-called trade usages. Under most national laws, arbitral tribunals as well as national courts would do so in any event in resolving commercial disputes, but Article 28.4 makes this obligation explicit.